I'm Michelle Churchman. I'm a consultant. I help out with stuff at DTI. I'd like to introduce our speaker for this session is Bill Denny, who's been with us for many, many, many years, doing really interesting presentations. He is a partner at Potter Anderson and Caroon LLP in Wilmington, Delaware, where he leads the practice in the area of cybersecurity, data privacy, and information governance. He is a certified information privacy professional, I'm not using the acronyms, and he's certified information privacy manager through the International Association of Privacy Professionals. He has represented public and privately held companies and government entities in a wide range of technology transactions, including negotiating complex cloud services agreements, software and IT infrastructure development, maintenance and support agreements, long-term material supply agreements, outsourcing agreements, transition and site services agreements. So with that, please welcome Bill Denny.
Thank you, and it's nice to be invited back to speak to you again. There's always more things to talk about in legal updates every year, especially in the privacy and data security area. There are new comprehensive state privacy laws, and there's been a tremendous rise, at least from a public perception perspective, in artificial intelligence, and it's created new legal and regulatory challenges for business. Delaware this year became the 13th state, the first state became the 13th state to adopt comprehensive data privacy law. Delaware passed its Personal Data Privacy Act on September 12th, I believe, of this year, and it will take effect on January 1 of 2025, and it's going to affect a lot of businesses in the state. So we're going to talk about that. We're going to talk about the changing privacy landscape and the difficulties in compliance, because different states have different rules, and most businesses are operating in multiple states, and compliance can be tricky. And it feels like a game of whack-a-mole, trying to figure out which law to comply with. We'll also talk about the current AI landscape and the scope of recent regulations and possibly how businesses will be affected, what the significant business issues are. So first, I'd like to talk about the comprehensive state data privacy laws. Every state has some form of privacy law. The 13 states now that have comprehensive data privacy laws absolutely affect how businesses operate in those states. And the laws seek to provide consumers with rights over their personal data, when it's collected, how it's processed by data controllers and data processors. So it's a little bit different from data security, which of course focuses on the confidentiality and the availability and the integrity of the information. Data privacy focuses on what the consumer's rights are over their personal information, how it can be exploited, what companies are allowed to do with it. Delaware's law is modeled after similar comprehensive data privacy laws adopted in other states. California was the first state to adopt comprehensive privacy regulation in 2018, followed quickly by Virginia and Colorado. California law was drafted by an activist without any legislative input and is a horribly written law. If you try to read it and understand it, you're going to go crazy. And so no state really wanted to adopt the California model. So the state of Washington carefully drafted Washington Privacy Act, it was called, and it was closely modeled on the European law, which is the GDPR, General Data Protection Regulation, and uses a lot of the GDPR terminology. Washington, unfortunately, has never been able to pass that law. It's been up every year, and it passes unanimously in the Senate and then fails in the House or something crazy. But every other state that's adopted a comprehensive data privacy law has modeled it on the Washington draft law. and some are more consumer friendly, some are more business friendly. Utah, for example, would be considered very business friendly. Connecticut would be considered very consumer friendly. Delaware modeled its on the Connecticut version of that law, so it tends to be more consumer friendly. The law in Delaware, I think we should talk about who it applies to and what some of the key concepts are. It applies to a controller. And a controller, that's one of those GDPR words. It's anyone who acts alone or with others to determine the purpose and means of processing data. So the person who is making the decisions as to how personal data is processed is a controller. And so this law will apply to controllers who conduct business in Delaware or who produce products or services targeted to residents of the state of Delaware. So it doesn't have to be a company located in Delaware. It could be a company located somewhere else that is gathering data on Delaware customers. And the consumer, and I use Delaware residents there, but the consumer is any resident of the state of Delaware, but not someone who is, you have their information because of an employment-related reason or a business-to-business type of reason. So the person who represents a business you're doing business with, that wouldn't count. But the consumers are every individual in the state. And so this law applies if you do business in the state and during the preceding calendar year, you controlled or processed the personal data of at least 35,000 Delaware residents, not counting payment transactions. And you know the financial services industry has a huge political pull in Delaware, so they're carefully carving themselves out one way or another. Or you control or process the personal data of at least 10,000 residents, and you get 20% or more of your gross revenue from the sale of personal data. So one of the big exclusions from this law, which takes out the biggest data processor, is government. Government is carved out of this law, except for universities. Organizations of higher education are within the law. Also excluded are financial institutions. Remember what I said about banks having their political pull? Those are the only entity exclusions. The data type exclusions are HIPAA data. So hospitals would be covered by this law, but not the data which is governed by HIPAA. And hospitals and other healthcare organizations have a lot of non-HIPAA related personal data. Scientific research data, consumer credit reporting data. There are a few categories of data that are excluded. The law in Delaware applies to nonprofit companies. And Delaware is almost unique in that sense. Only Colorado and Oregon also have laws that apply to nonprofits. There are some narrow exceptions to that. If your nonprofit is dedicated exclusively to addressing insurance crime or helping the victims of, helping crime victims, you're excluded. But this is going to be a big surprise to nonprofits. Nonprofits can be very big, they can be dealing with a lot of data, and they have traditionally not felt themselves subject to these data privacy controls. So of course, all of these different state laws and how do you comply, what do you comply with, but there are a number of consumer rights, and they're not all the same in different states, but generally, and these are true in Delaware, that a consumer, an individual, has a right to confirm whether a controller is processing his or her personal data and to access that data to see what it is. They can correct inaccuracies in the data. They can ask that the data be deleted, and not only data collected from them, but data collected about them from third-party sources. And this is different in different states. Some states don't allow a consumer to require deletion of data collected through someone else. And it's what's called a data broker, somebody that sells personal data to other companies. So Delaware requires that the customer can control whether that's deleted. They can obtain a portable copy of their personal data to transfer elsewhere. They can obtain a list of categories of third parties to which the data has been transferred, and they can opt out of certain processing. And opting out creates one of the huge obligations for companies. They can opt out of targeted advertising, of the sale of their personal data, and the definition of sale is broad. It's not only getting money for data, but it's any valuable consideration. So if there's a swap of information, that's considered a sale. And you can opt out of profiling. That is automated processing of your data to make a decision that has some significant legal effect on the consumer. That is profiling. And when we get into AI, we'll think about profiling, because AI is an automated decision-making process. People use AI for hiring and for all kinds of different things. This allows the consumer to opt out of that. Well, how's a company going to manage opt-out requests? And if you don't manage it correctly, then you're in violation. There are also specific requirements for opting in, meaning that a company is absolutely prohibited from certain kinds of processing unless the consumer opts in. And this would involve the processing of sensitive data. And Delaware has a unique, other states have definitions of sensitive data, but Delaware's is unique in that Delaware's definition of sensitive data includes genetic information and includes biometric data, which is used for identifying a person. And also, express opt-in is required in processing data for minors. And many states have an age for considering processing of data for minors. The federal law had the age of 14, and some states have moved it up to 16, and Delaware has set an age of 18 to be considered minor, and there's only, I believe, one other state, which is Connecticut, that just this year raised its age for minor for purposes of data privacy to 18. So there are a number of business obligations, and there's business obligations for controllers, and for the other category that I didn't mention is processors. And a processor is anyone who processes personal data on behalf of a controller. So if you're a company and you're collecting personal data and you're determining what to do with it, you're the controller. But if you hire a data processor of some sort, if you hire a service provider and they're actually doing something with the data, they're accessing it, they're looking at it, they're manipulating it, they're a processor and they're subject to this law, even if they don't meet the threshold that has been set. A controller has to limit its collection of personal data to what's adequate, relevant, and reasonably necessary in relation to the purposes that have been disclosed to the customer. They can't just collect as much as they want for any reason. They have to use reasonable data security practices, and they have to provide consumers with a privacy notice. And not just any privacy notice, but it must contain a number of different types of information. And so compliance with creating a privacy notice is very strict, and different states have different rules in what has to be in the privacy notice. And the privacy notice has to be accurate as to what you're really doing. Don't take a generic form off the internet and change the name of the company and say that's my privacy notice, because the Federal Trade Commission will say you're committing an unfair and deceptive trade practice if you do that. If your privacy notice is not sufficiently transparent and doesn't accurately reflect what you're doing, then the Federal Trade Commission will say that you're deceiving the public, and they will cite you for that and investigate you, and that's an expensive process. Companies have to comply with the opt-out requirement, which involves considering whether they're engaging in targeted advertising, whether they're engaging in profiling. Are they using AI? Does AI have access to the personal data? And how is it being used? There's also a situation in the Delaware law that requires controllers to comply with a universal preference signal. And there are only a couple of others, well, 3 other states, Colorado, Connecticut, and Montana, that require the same thing. And that is any sort of automated means on the internet which would allow a consumer to indicate his or her preference to opting out of particular uses of their data. And to the extent that is broadcast out and is generally available and is not discriminatory, and there's a few other requirements, companies that are subject to the Delaware law must comply with those opt-out principles. And the opt-out, recognizing the universal opt-out principles doesn't come into effect until a year after the law comes into effect. So there's a little bit of a grace period. So processors, and that can be a small mom and pop company, it can be a small company that does work for a controller, they have to adhere under this law to the instructions of the controller as to what to do with the data. And there has to be a contract in place that governs data processing procedures, the nature and purpose of the processing, the types of data, how long they can keep the data, and what they have to do at the end. So there's a lot of contracting requirements, and if your contract does not comply with the law, then it's deemed to be a sale of data. And if it's a sale of data, it's got to be disclosed to the consumer, and the consumer can opt out of it, and it's all kinds of confusions. Otherwise, you're violating the law, and it's an unfair trade practice. And so even the small companies that are doing business with controllers, they're going to have to renegotiate their contracts to put in all of the provisions that are required by the new law. There are data protection assessments for slightly larger companies. Controllers that control or process not less than 100,000 consumers have to engage in data protection assessments on a regular basis every one of their processing activities that presents a heightened risk of harm to the consumer. And what kind of processing creates a heightened risk of harm? Well, any processing that deals with targeted advertising, it deals with the sale of data, or that deals with profiling of data or processing sensitive information. And the Attorney General has the right to come and ask for your data protection assessments. These are not protected information. And the assessment must weigh the risk and benefit of the processing. I've talked about some of the major challenges to compliance, and that is that this can affect small and medium-sized businesses, including businesses as small as processing 35,000 individuals. And other states have different thresholds, but they also have larger populations than Delaware. So 35,000 people in Delaware is about 3 or 3.5% of the population. And many other states have a threshold of 100,000 individuals, but that is an even smaller percentage of their population than Delaware's percentage. California also has an income threshold, so you're not subject to the California law unless your gross revenues as a company is over a certain limit, but there's no income threshold in Delaware. The definition of sell is broad. It, like I said, is not only monetary consideration, but it's any consideration. And so a nonprofit who is sharing its donor list with other nonprofits, they're going to find themselves in a situation where they're considered to be selling data. And any violation, fortunately for companies that are trying to comply, there's no private right of action. California has a limited private right of action where a company can sue, an individual can sue a business or have a class action lawsuit against a business that has suffered a data breach that is tied to breaching the consumer data privacy law. In Delaware, it's enforced by the Attorney General, and a violation of the Personal Data Privacy Act is deemed a violation of the Consumer Fraud Statute. And under the Consumer Fraud Statute in Delaware, there can be a penalty of up to $10,000 per violation. And per violation is generally interpreted as per individual whose data was breached. So if you have 35,000 individuals in your database, obviously that hypothetical number could be huge. And so what should businesses do to prepare for this? Well, the most important thing to do is understand what data you collect, and is the data that you collect necessary for what you're doing, and what are you doing with it? Where is it located, and who has access to it? Because when an individual contacts that business, the business needs to tell them what information they have on them. So controlling your data is important. Second is updating policies and procedures to make sure they comply with the new law and that you have procedures in place internally to process requests from consumers, to carry out opt-out requests, make sure they're enforced, and any requests for deletion of data or providing data, and make sure that you have a dispute resolution mechanism in place if a consumer has a dispute. Also, if a consumer requests information about what data you have on them and they ask for you to give them the data, you better be sure that you've authenticated who this person is asking for the information. Because what if a hacker contacts you and says, I'm Jane Smith, what data do you have on me, and send it all to me? And the company very, very innocently sends it all, and it's not Jane Smith, it's some hacker in China who's getting your information. Not that I would pick on China, I'm sure they're... But there's a significant liability issue. It's considered a data breach if you send the information to the wrong person. So there needs to be an authentication method for people that contact you. And what if you deny someone access to their data because you can't authenticate them? Well, there's a dispute resolution process, and they have 45 days. Well, you have 45 days to respond to a data request, but then the consumer has a right to appeal your decision. And there has to be an appeal process that every company, large and small, has to set up internally. So a little bit of work to do. So related to data privacy, obviously, is artificial intelligence. And the big question is, what is AI? And if you asked that question in the 1950s, what is AI, you'd get a different answer than today. Computer scientist John McCarthy coined the term artificial intelligence in 1955. And he defined it as the science and engineering of making intelligent machines. Well, that doesn't tell you a whole lot. But he organized the Dartmouth Summer Research Project a year later in 1956, and that's pretty much considered the dawn of AI as a concept. And there's an odd paradox, because as computer scientists find new and innovative solutions, the computational techniques that were once considered AI sort of become common and repetitive, and they're no longer considered AI. So maybe AI is just the new stuff that we're not used to yet. There are a number of laws, and the definitions of AI are legion in many different laws in many different countries. The definition from the National Artificial Intelligence Initiative Act of 2020, that's a US federal law which is still in effect today, is a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. And then it's got a number of examples. And so it's kind of a complicated definition. But there's a lot of different kinds of AI, and one of the kinds of AI we see now is generative AI. And the big one that has gotten a lot of popular press and we see is ChatGPT. So trivia question for all of you technologists. Of course you know what GPT stands for. Okay, I heard generative. What's the P part? Pre-trained. T. Transformer. Generative pre-trained transformer. Yeah. So ChatGPT is a mathematical model on top of training data. So it has generative AI in a general sense, and ChatGPT in particular, has scraped data from lots of different sources, huge amount of data. I think ChatGPT has scraped everything from the internet up to 2021, or at least at one point that was its limit. And it uses this training data to predict outcomes based on a statistical pattern. So it's not smart in any sense. It just uses mathematical models to predict outcomes. And so it clusters different patterns together and creates associations, if one thing, then another thing. And that's the unsupervised part of ChatGPT or generative AI. But there's also the supervised approach which comes on top of that, and supervised means with humans. And that is, they look at different outcomes of the model and they say which outcome looks right and which outcome looks wrong. And they try to train the model to get better. Human feedback identifies what's the best response. And there's many, many use cases for AI and generative AI that businesses are using. In the manufacturing context, predictive maintenance, which machines are going to fail. Computer vision ensures quality control. In the healthcare space, and there's some of you that are involved in the health industry, patient risk identification for proactive care. You can put in patient medical history and you can predict who's likely to have different events much better than even a highly trained doctor would be able to do. And drug and molecule discovery to accelerate research. In the retail space, store floor planning, how to predict patterns of traffic and how that'll affect purchases. In financial services, for fraud detection. In employment, for virtual interviews of applicants, and for procurement and expense trends. For marketing, to segment customers and determine how to sell products better, and chatbots to enhance customer service. So there's lots of uses, and of course, lots of uses mean there are lots of issues with it. One of the big issues is, which relates to privacy, is loss of protected data. What data has been fed into the generative AI system which is protected in some way? Where does the data come from? The training data set becomes critically important as companies decide if they can use it. There are intellectual property issues, and we're going to talk a little bit later about copyright. To the extent that the generative AI system has taken in copyrighted data, what happens when it produces data which mimics a work that is copyright protected? Accuracy is a huge issue. There's something called hallucinations, where the generative AI will give you a result with a high degree of confidence that is absolutely wrong. It will just make up information. And you'll have no way. It will quote sources, and it will give you the title of articles, and it'll give you the page number that the article starts on, and it's all made up. Because it's just a predictive tool based on statistically looking at information that it's scraped. So another issue is explainability. Nobody can really explain how the generative AI, different generative AI systems, come out with the recommendations that they do. I mean, a simple example of a great use of AI is in radiology to detect breast cancer. That they've used AI very, very successfely to look at radiographs and predict people who are likely to experience breast cancer, and that's great. But in many consumer-oriented applications, the business has an obligation under current regulations to disclose how they are reaching the recommendations they are. And to the extent that you can't explain what's happening in these systems, it creates a problem. And of course, I mentioned about the hallucinations. Another risk, of course, is the deep fake. You'll see a video of President Biden declaring war on North Korea, something that could cause a major global upheaval if a false rumor like that were to get out. And generative AI can generate deep fakes that are very difficult to detect. And as AI gets better, the deep fakes get better, and we are not prepared to, with the tools, to be properly skeptical about what we see and hear. Privacy and bias. What's the training data? I'm going to give you a few examples where that can become a significant issue. And one of them is hiring practices. So here's an article about Amazon using AI as a recruiting tool, and it showed bias against women. Well, why would Amazon's tool to hire technologists show a bias against women? It's trying to predict who is going to be the best technologist when it reviews a resume. Well, most people in technology historically have been men. And so the database is mostly made up of men in that profession. And so when the AI tool scrapes all that data and takes unknown data points to determine who's going to be the best recruit, it's going to have a bias in favor of men. So how to guard against that is a challenge. Similarly, many law enforcement organizations are using AI to determine who is most likely to commit a future crime. And this applies to setting bail for someone who's been arrested, sentencing for someone who's been convicted, and there's been lots of examples where AI is absolutely biased and will be biased against a person of color who is I mean, you can compare, and it's the person on the right who is a white man who has a long criminal record and was quickly reincarcerated again, but he had a very low rating by the AI for recidivism, whereas the person on the right, who did not have a criminal record, was given a higher rating for recidivism. So this type of this is a huge risk in where you're getting training data and how it's being processed. And another, which is similar, is child protection. Many social services organizations use AI to determine which families to investigate for potential child abuse or not taking care of the children. And so, so the question is whether they're reliable. And when you don't know how they work, it's hard to say how they're reliable. In the in more of the hallucination risks, there is a case that gained notoriety. This is the ChatGPT lawyer. I don't know if any of you have heard of the ChatGPT lawyer. He was representing a plaintiff in a personal injury matter, and the defendant moved to dismiss, and he wrote a brief in response to the motion to dismiss, something I've done all the time, but I've never used ChatGPT to do it. Well, he used ChatGPT to write his response, including case citations to the law that he filed with the court. Well, the defendant couldn't find the cases. And the defendant raised that with the judge, and the judge told the plaintiff, we want you to submit an affidavit that says these are real cases, and we want you to give us copies of the cases. So did the lawyer confess, well, I actually used ChatGPT? No, he didn't. He used ChatGPT to generate the cases. And he submitted fake cases to the court. Well, I know. Don't ever do that. they determined that the ChatGPT fabricator, and of course there was a sanctions hearing, and he was severely sanctioned by the court for conscious avoidance of his obligations and for false and misleading statements to the court. So they didn't rule you're not allowed to use ChatGPT. They just ruled that you are responsible for the output. You're responsible for what you file. So if it gives you information, use it as a starting point, but you better verify the information. And the key takeaways are that you just have to watch the output. Now, the copyright issues. An example here is there's a class action lawsuit against a company called AI Image Generators, and it's brought by artists whose work is on the internet. And AI Image Generators scraped all that up and uses it for an artificial intelligence tool that generates supposedly new works of art. And they're alleging copyright infringement. How are the artists going to be protected if AI is going to use their works to create new works? So what they're saying is they infringe on copyrights because the models were trained using billions of copyrighted images. And the complaint alleges that these new images should be treated as derivative works. And derivative works is a term of art in copyright law. That means you've created a work from another work. AI Image Generators filed a motion to dismiss. They argued that the AI-generated images are not sufficiently similar to the copyrighted works to constitute infringement. And they said that the artist did not identify specific image content that was created using the AI models and did not identify specific works that were copied. And so the court is currently considering that motion to dismiss. But it just raises the question of what are the outer bounds of derivative work and how are we going to protect artists? And there is fair use of copyrighted works, and fair use includes criticism and comment and news reporting and teaching and scholarship and research. You can use copyrighted works for all those things, but this falls well beyond what would be considered fair use. So there are laws. The current laws in place apply to AI. AI seems like a new area, but many current laws apply, and I think the one I'd like to focus on is the Federal Trade Commission, because the Federal Trade Commission enforces protection from unfair and deceptive trade practices. And the Federal Trade Commission has gone after companies and is investigating companies that use AI. And some of the lessons, some of the takeaways from these investigations are that make sure, if you're using AI, that your claim accurately reflects the tool's abilities. Don't overpromise. Otherwise, you're deceiving the public. Take measures to prevent consumer injury with how the AI is being used. Make sure the automated tools don't have biases or discriminatory impacts. And again, this is extremely challenging. How to do that? Ensure you understand, ensure that you can explain how the algorithm is generating the outcomes. I don't know if that's possible, but the FTC is expecting companies to do that. Be aware of the risks and be aware of the data that's used to train the data sets. So companies are using AI in their business, and they need to make sure, and what I'd like to get to soon is some of the contracting issues that companies have to be concerned about when contracting with an AI-based service provider who's providing an AI service. So there are state privacy laws governing AI, and we talked about profiling. And profiling is essentially an automated decision-making tool, and there are requirements that require a consumer to be able to opt out of that. And so you have to disclose to a consumer, if you're using AI to profile them for purposes of targeted advertising or something like that, and they have a right to say, I don't want you to use that for me. And then you have to carry that out. Well, Colorado has unique requirements. And why do we care? Because if we have a nationwide business, then we need to comply with the laws of each state in which we operate. Colorado's law requires that you disclose the logic and training used to create the AI tool and whether the AI tool has been evaluated for accuracy, fairness, and bias, and why you're using the AI tool. So this is, they're trying to get a lot of disclosure. European Union, of course, as usual, is ahead of the game in terms of privacy and security regulation. And they've passed an AI Act. And AI Act does various things, but one of the things it does is it categorizes the use of AI into different categories, from unacceptable risk to high risk to generative AI and to limited risk. And it prohibits unacceptable risk, and it has minimal transparency regulations on limited risk. But there's just additional steps that companies need to consider and go through. The future of AI regulation includes potentially the federal data privacy law, which I thought was going to be passed a couple of years ago. So never mind that presentation I gave here 2 years ago that I told you it would be passed. But the draft includes engaging an external auditor to evaluate the design and structure and data inputs of AI tools to reduce the risk of discriminatory impacts. Senator Schumer has introduced last year the SAFE framework. SAFE stands for Security, Accountability, Foundations, and Explainability. And it would require, and it's a framework for future regulations by Congress. I don't expect it in the next 2 weeks. Congress has other things I think it's worrying about right now. But this would require disclosure of who trained the algorithm and who the intended audience is, what's the data source. And so these are going to come up and are important for people developing AI to anticipate as they're developing their product. The White House Office of Science and Technology outlined a voluntary framework of 5 principles and associated practices to help guide the responsible design, use, and deployment of AI. So this is all guidance. It's not mandatory. They're trying not to restrict development of AI, because what happens if the US passes laws that say, whoa, this AI is dangerous, and it is, and it can be used for dangerous purposes. If there was a law restricting development, well, the development's not going to get restricted in other countries. So there's a competitive issue, there's a national security issue. So the best they can do is try to steer the development in a way that is best. And the first principle is that it be a safe and effective system. And the next principle is that it protects against algorithmic discriminations, such as what we discussed. The third is that it takes data privacy into account and respects data privacy. The fourth is that it provides proper notice and an explanation for what it's doing with the data. And then finally, there should be fallbacks. There should be human alternatives if somebody objects to AI being used, and there should be consideration for that. So all of those are challenge for developers. In the commercial context, my favorite subject, there's many different agreements that go into a business using AI, which includes data licenses and platform agreements and service agreements. And these all contain a number of issues. And let me just touch on 3 issues. One is training rights. Reddit, do any of you use Reddit as a social media platform? Well, Reddit has created restrictions as to the use of its data by bot scraping, by bots that scrape for data. So that they want to prevent AI companies from scraping their data without paying for it. And so you need, so the issue of whether the company that you're contracting with has proper rights to the data that it used to train its tool is critical. The other are use restrictions. Companies that license AI technology typically contain restrictions as to how you're allowed to use that AI. And for generative AI, it can be used for just about anything. Things you would never even think of, but tools that are commercially licensed, they'll say, well, you can't use it for anything illegal. But they'll also say, you can't use it to develop a competing product to our product. And so if you're using it for product development, you might be stuck. A third category is output. What if it creates hallucinations? Who's responsible for that? The company that's providing the AI tool may have no way to filter for it, and the technology is not good for filtering for there. So there are a number of considerations of what businesses should do, such as weighing why they want to use AI, mapping out how exactly the system works, updating their policies, testing the system, make sure it doesn't have a biased approach, make sure that it's being used in accordance with their corporate governance, and managing the risks. So I'd love to address any questions. Yes?
Yeah, just from the first half of your presentation, very near and dear topic to me. I did my final project on kind of compiling all of the data privacy regulations around the world right now. And what I noticed throughout the research was, GDPR got passed back in 2016, went into effect in 2018. Then a lot of other countries were scrambling to catch up. But the U.S. has been far behind even some of those other countries. So, between 2018 when the GDPR went into effect and 2020, we had a few states come out like California and try to make their own privacy regulations. But at the start of this year, we were sitting at 7. And by June, halfway through the year, we were at 10.
Yeah.
And now
We're at 13.
We're at 13.
Yeah.
So, the worst part about this from a compliance perspective is how exactly our business is going to comply with all these regulations that are coming out so fast, and
Yeah.
why the U.S. On a federal level has had the federal regulation fall through for the last 3 or 4 years, oftentimes not even receiving a vote at all. So,
Well, the federal government hasn't been able to pass a law because there's two different opinions as to preemption. Does it preempt state law or not? Half say yes, half say no. And should there be a private right of action? Half say yes, half say no. Until those two issues can be resolved, we're not going to have uniform law in the U.S. So compliance is very difficult and takes constant vigilance. Yeah, thank you. Yes, sir.
Seems to me that there is or should be a buyer beware or user beware. I use the Bing chat tool fairly extensively, and I find two kinds of errors, and I get two responses from when I challenge the error. One is an inconsistency error.
Yeah.
They say two conflicting statements. You point that out, and it apologizes. The second type of error, it shows an arrogance. You'll say, this answer is wrong, I checked, I verified. And he says, absolutely. The onus is on you. It tells you this.
Right.
It is your responsibility. And it's along the lines you said. I gave you references, data. It's up to you. And the bottom line is up to you on how you use it and is it correct.
Right.
Check my references.
Well, I'll ask you one question. How much do you pay for using it? You don't pay anything. If you don't pay anything, you're taking a lot of risk on yourself. Exactly.
Your points, which are hardly worth anything, but
Right.
nonetheless, if anything, you're being paid to use it to help train the tool.
No, you're training them with every question you ask, and they're watching you, and you're giving them data.
But anyway, does that give them an out? That one, you don't pay for it, two, they gave you references, and bottom line, user beware.
Yes, I'm sure that's all in the terms of use, and they're on the website. Yes.
Wait, just real quick. Folks, we are into lunchtime. Please feel free to stay and ask your questions. And also, if you have surveys, please fill them out and leave them in the chair in the back.
Thank you.